Okay. Is this a bit more clear? Okay, perfect. Great. So Alison and I, as Nalini said, we are from RavenLaw, law firm in Ottawa with offices in Kingston and Winnipeg. And three of our lawyers are involved in Nunavut. And so we're happy to be here with a presentation sort of, and I think we can take from it what we so both from a personal level, a professional level as an employee or a mentor or an employer, and take bits and pieces to apply to our day-to-day. And also for lawyers who don't practice necessarily in human rights or accommodation, to get a bit of a framework that. So I think it's an understatement that the last 2 years have been challenging. The pandemic, isolation has been really hard on all of us. And for the lawyers in the room or online, our professions can be quite stressful as well. So that all that together, I think, has led to a movement of openly talking and about mental health and mental wellness a bit more. And I think that's probably one of the silver linings of the past 2 years is an openness to talk about this within the community, but also within workplaces. So our goal today is to give you sort of a very sort of basic legal framework in terms of what is, harassment in the workplace, what is an accommodation process, what does that look like, with the lens a bit more focused on mental health, and then as well, what are the options as an employee if things aren't going well and we're not able to continue working. And then our Pauline from the Mental Health Commission will talk about wellness and strategies as well that we can use personally, but that maybe we can communicate as well with our colleagues as to how to sort of facilitate when things aren't going well. That's about it. Alison, you go ahead.
Okay, so I'm going to give you sort of a general overview of the law around discrimination, duty to accommodate, where to look, and sort of a high level idea of what steps you can take. So if you have discrimination or an accommodation type question, the first thing you always have to do is go to the legislation. So the Nunavut Human Rights Act is going to apply to anyone that's territorially regulated, but the Canada Human Rights Act is going to apply to the government of Canada or any federally regulated employer or service provider. So you're thinking like post office, banks, aviation, those are actually all federally regulated. So you want to make sure you're looking at the correct act, right? So it's going to be the Nunavut Human Rights Act for some and the Canada Human Rights Act for the other. What you should know about both of those is human rights legislation has been given what they call a quasi-constitutional status. And that means it essentially prevails over other law. So for example, if an employer ends the employment of an employee, they have to give them reasonable notice. So that's sort of what the common law says. If you're going to end someone's employment, you have to give them a certain amount of notice. But human rights legislation says if you're going to end someone's employment, you can't do it for a discriminatory reason. And because human rights law prevails, the answer is, as if an employer ends an employee's employment, even if they've given them reasonable notice, it's still an illegal termination if it's for a discriminatory reason. So you've got to remember that whenever you're looking at human rights law, it sort of prevails over other law. And because it sort of has this quasi-constitutional status, you've got to give it a really broad and purposive interpretation, right? So quasi-constitutional means essentially in Canada, the most superior law is the Constitution, right? It governs everything, and it's the law that everything else has to comply with. So human rights law is not quite at that level, but when we call it quasi-constitutional, what it means is it's going to prevail over other laws. So if there's two laws in conflict, usually your human rights law is going to prevail, right? Because human rights have that extra status; they're extra important. Okay, so. What is discrimination, right? Because that's what the Human Rights Act, both the Nunavut and the Canada Human Rights Act, are trying to protect against. And discrimination in a legal sense is just when there's unequal treatment or opportunity for a person or group based on a characteristic. These are usually called, you'll see them called enumerated grounds, and they're listed in the legislation I just talked about. So if a person or a group is getting different treatment because of one of these enumerated grounds, and they're things like age, sex, race, gender, religion, those kinds of things, then it's discriminatory treatment. One of the most important things to note about discrimination is you actually don't require intent. So people often think, well, that wasn't really fair treatment, or I was treated differently, but they didn't mean it. It actually doesn't matter, right? Even if they had no genuine intent to discriminate against you, it's still discrimination, okay? So remember, intent is actually not required to find discrimination. There are about 5 different types of discrimination, and I'm just going to give you a quick overview of each of them. So the first is direct discrimination. This is the obvious one you're thinking about, and it's usually the most easy to identify. So for an example, if an employer says, oh, you know what, you have kids, you can't have a promotion, you don't have time. That's direct discrimination. Like, you have kids, family status, you can't have this promotion. That does happen, and it's important to keep an eye out for it, but most discrimination is actually more subtle than that. So the second type of discrimination I'm going to talk about is indirect discrimination. And that's where a rule looks neutral on its face, but the effect of that rule is actually discriminatory. So for example, if you had a rule in the workplace that says no hats in the workplace, that sounds fair, right? Like, that applies to everybody. Wearing a hat does not seem like it's a protected ground. But if a turban was considered a hat, now indirectly it's discriminating on the basis of religion, right? So there's a disproportionate and a differential effect for people with certain religious beliefs. So that's what indirect discrimination looks like. It looks neutral on its face, but the effect of it is actually discriminatory. A sort of similar type of discrimination is what's called systemic discrimination. And that's when essentially it's almost built into certain types of behaviors, institutions, right? It's a pattern of behavior, or it's policies that create or perpetuate a disadvantage based on one of the enumerated grounds. So one thing you often see in systemic discrimination is under-inclusion. So it's about not getting a promotion, being excluded from certain work events, being paid less than your peers. That kind of thing is systemic. It's built within the system. It's not necessarily a rule. There's no rule that says, hey, you can pay this group less than that group for the same work, but it's built within the system. So for an example of this type of thing would be if an organization has all of its important meetings in the evening. Anyone who has kids is going to have a hard time attending those, right? Because they have to find childcare. Or often, sometimes if managers have come up from different systems, I actually did a case like this, women who were coming up from a certain administrative system were paid less. And then when they got to the management role, they got a 15% bump. But because they were coming up from different positions than their male counterparts, once they were all managers, women were always paid less because they got the same 15% bump, but because their jobs were valued less initially, right? So that would be systemic discrimination. Again, there's no rule, but the system as a whole is actually creating a discriminatory practice. The fourth one you want to keep an eye out for is something called a poisoned workplace. And it's created, a poisoned workplace is essentially when the workplace has become so intolerable that a person can't work there. And it's usually created by a series of wrongful behavior. You're looking at comments or conduct that ridicule a person. And essentially the workplace has become hostile or intolerable. You do have to have what they call objective, reasonable, a reasonable bystander would view it as offensive. So, you know, you can't wear purple nail polish in the workplace. That's maybe, you know, that's a rule that applies to you, but that's not on an enumerated ground, right? You need sort of an objective, reasonable bystander. And so you're looking for persistent or repeated behavior. And this ties in with the last form of discrimination we often cover, which is harassment. And harassment happens when someone shows a vexation pattern of doing or knowing something and based on an enumerated ground that they know or ought to know is unwelcome. And what's important about that definition is, again, harassment doesn't require intent. right into that definition of harassment, we've built in the idea that it doesn't require intent. So that this is one where you often see people say, oh, they're, this isn't really comfortable. They're just saying these things to me. I don't really like it, but they don't mean it. It doesn't matter. They don't have to mean to harass you for it to be harassment. And so you're going to want to keep your eye out for that. And harassment can be things like sending around emails, right, with jokes aimed at people, leaving people out. All of these things can constitute forms of harassment. One thing that we're going to talk a lot about today, and I just want to flag, is the idea of disability, right? And so disability, we've got to remember, because of the quasi-constitutional important nature of human rights, you want to make sure you're interpreting disability broadly. So there's sort of the old way of viewing disability, which was about the medical condition. Does this person have a medical condition that actually prevents them from doing something? But a newer way of looking at disabilities, it's not something a person has, but it's a social construct. So you can face discrimination on the basis of disability if someone believes you have a disability and you don't have one. That's still discrimination. They assumed you had a certain condition or disability and they didn't, and so they discriminated against you. You can also face discrimination when you have a disability and someone makes assumptions about what you can do. So if you have a certain medical condition and people say, oh, we can't give her that job because she has that condition. That might not be true. You might be able to do the things, right? So that's also discrimination on the basis of disability. So the idea of disability is now much broader than it used to be, and we have to remember that when we're thinking about discrimination on that basis. So now that I've sort of covered what discrimination is, how does it work? Under the legislation, what happens is if you or as a group or a person are claiming discrimination, you have to make out what's called a prima facie case. So you have to essentially put all the evidence out there. This is what's happened to me. And if believed, it would show discrimination. So there are 3 steps to a prima facie case. 1, you have to show you have a characteristic under the legislation. Again, remember I talked about the enumerated grounds under the legislation. You have to have one of those. So, they discriminated against me because I wasn't allowed to wear purple nail polish. That's not an enumerated ground. You don't have human rights protection. But they discriminated against me based on my sex, color, ancestry, ethnic origin, citizenship, creed, religion, age, disability. These kinds of things are an enumerated ground. So the first step to proving a case of discrimination is you have an enumerated ground under the legislation. The second step is you have to show that you had what's called an adverse impact. And this can be a variety of things, right? So it can be under inclusion. It can be I didn't get hired for a job. I didn't get a promotion. I was fired, all sorts of things. But you have to show something bad happened to me. So you have to have an enumerated ground. You have to show an adverse impact. And then you have to show that the protected characteristic, the enumerated ground, was a factor in the adverse impact. And the important thing to remember here is people get tied up, sort of like with the intent question, people get tied up, well, it was maybe part of the reason, but they had this other reason for firing me or not promoting me or whatever. But human rights legislation is really clear. The enumerated ground doesn't need to be the only or even the major reason, as long as it was a part, as long as it was one reason you experienced that adverse impact, then it matters. Right? So if you don't get a promotion, for example, and it's all based on poor performance, okay, well, you didn't get a promotion because you weren't performing well. But if you didn't get a promotion, they said to you, it's your poor performance. And I think that's because you have kids, so you don't have time for this performance or for this promotion. Now we've got discriminatory conduct. Yes, part of it was you had poor performance, but part of it was they said you had kids and so they don't think you have time. So it doesn't need to be the only or even the major reason for the adverse impact, but you need to be able to tie the two together, right? The characteristic and the adverse impact. Okay, so that's how you prove a prima facie case. Once you've done that, the burden then flips to the person, usually the employer when we do our cases, to show that they couldn't accommodate you. They have then what's called a duty of accommodation, right? So that is also a 3-step test. They have to show that they adopted the standard or purpose or rule or decision was rationally connected to the performance in the job. They adopted it in an honest and good faith belief it was necessary for the job. And they have to show that there was no way they could have adjusted it to accommodate you. That's called the duty to accommodate. The first two, so one, is it rationally connected? There's not a ton of case law here. Normally this one is, you're able to prove it. All you have to do is say, you know, the reason I adopted this standard or this rule or this decision was related to my decision. So for example, you have to have a performance rating of at least 3 out of 5 to get a promotion. That makes sense, right? Like it's tied to the job. You have to only wear black to get a promotion is not rationally tied to the job, right? Like there has to be a reason that they're implementing this rule or policy or decision. I will tell you most of the time they're able to show it because it's very rare that they made a decision or there's a rule that's totally unrelated. So rationally connected usually is met. Same thing with honest and good faith belief. There's rarely evidence that the person discriminating was doing it for the sole reason of discrimination. They usually were doing it because they honestly and good faith believe that this decision was necessary. So where the meat of the case law and where most of the time the argument is what's called the duty to accommodate. And the question in the duty to accommodate is, could the rule or decision have been adjusted in a way to accommodate the person with the enumerated ground? So for example, if you put all of your meetings in the evening, and this means anyone with childcare obligations can't attend them, do they have to be in the evening? Could they be at lunch? Could they be at other time during work hours, right? Could you have changed that rule in a way that meant that the discriminatory effect was lessened or eliminated, right? That's the duty to accommodate. You have to essentially try to change things to accommodate people. And so, for example, if they're gonna say no, and you have to do that to a level of what's called undue hardship. And what undue hardship tells us is there's going to be some inconvenience. You can't say, well, I could move the meetings from after work to 3 p.m., but you know, I don't want to do that. I don't like that. I like meeting at 5 better. That doesn't, you can't find, perhaps that person does like meeting at 5 better, but that's not undue hardship. As opposed to, I can't move the meetings from 5, you know, because we have people on the West Coast and we can't accommodate blah, 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 right? So you have to look at why if they're saying, no, we can't possibly change this rule, we can't accommodate people, you have to look at the reasons why. And bald assertions are not going to be enough. I don't want to, I can't, it costs too much. That's not enough. You can't just say that, right? So the standard of proof here is very rigorous, again, because human rights are so important when considering whether or not you could have accommodated or changed the rule to eliminate discrimination. The standard of proof is really high. So again, the personal opinion of the person doesn't matter. And if the only reason is cost, it would cost more to have the meeting at 3 p.m. as opposed to after work. The cost has to be extremely high. They have to bring lots of evidence about why they couldn't possibly do it any other way. So cost will be considered, but for it to be the reason you can't accommodate someone, you have to bring a lot of evidence and the cost has to be unduly high.
Would that be fair, Alison? And maybe you can't repeat the question on the night. Like if you're a small not-for-profit, small community organization, or if you're government, then it's not the same threshold of standard or meeting those requirements.
So the question was, does the cost threshold or any of the thresholds change depending on whether you're, for example, a large government body with lots of resources versus a very small employer? The answer is yes, a little bit, right? So for example, if you can show if you're trying to accommodate someone, for example, they can only work half days. They've had an injury, they've had an illness, whatever it is, they can only work half days. If you have 5 employees, you might be able to show, I can't have someone only working half days because the amount of overtime I'm going to have to pay is very high. I only have 4 other employees to cover. That will be a harder argument for a large governmental body to make because they have so many people, they could divide up the work. So they could probably do it without overtime. So the answer is yes, but if you're a small not-for-profit or small employer, you want to be very careful. The standard is still going to be high. It's just, it might be easier for you to show that the cost to you, you know, if you're going to rack up $10,000 in overtime every month, if you're a small not-for-profit, that might be untenable. To be frank, if you're a large government body, that might be reasonable, right? So it's gonna depend a little bit.
And just on that, Alison, I think one of the major takeaways of accommodation cases is they're so case by case and fact specific. So in one case, you could have someone come up with sort of an accommodation request, but you have to look specifically at sort of what the employee is asking for, what their sort of personal requirements are, and that specific employer to see whether or not, you know, in that specific case, undue hardship can be met or can be proven. But, you know, as lawyers, we tend to, you know, we go to the case law, but one change in a fact can really change your whole case, even though a lot of it will be very similar to other cases. And one of those would be depending on the employer, right? And so I think that's one of the takeaways is we have to be analyzing these cases on a very individual and case by case basis to make sure that if you are an employer that you're, you know, considering things specific to your employee's requests.
Absolutely. And the other thing to remember is you have to furnish concrete evidence. You can't just say, well, it would cost me too much in overtime. And they say, how much? Like, I don't know, $50,000. Like, you're going to have to show, if you're saying, I can't change this rule to eliminate the discrimination, you're going to have to provide concrete evidence. You're going to have done the math, shown what it would cost, showed how you have to change around the schedules. The other thing is often one that employers try and use to justify it is, oh, it's a health and safety risk. I can't possibly change this rule because it's a health and safety risk. Again, you're going to have to show how. So for example, it's a health and safety risk to have the meeting at 3 instead of 5. Well, you're going to have to provide some very, very serious evidence showing why that is. Whereas it's a health and safety risk, no hats in the workplace because it's a mine and you have to wear a full gas mask and there's no gas mask that will fit over a turban. Okay, now we're talking about a health and safety risk that might actually exist. But even there, you're going to have to furnish concrete evidence. A bald assertion is not enough. You have to have evidence. So a few things that a court or tribunal will look for when an employer is saying, I can't accommodate. I'd say it's what's called a bona fide occupational requirement, meaning it's an actual requirement for the workplace. And I can't accommodate, it would be undue hardship for me to accommodate. A few things a court tribunal is going to look for an employer to have done is, have they investigated alternate options? So to say I can't use an alternate option, they're going to have investigated alternate options. You just can't say there's no alternatives. Well, did you look at any? No. Okay, well then you don't know if there's no alternatives. And if they did look into it, why didn't they adopt those alternative options? Like why, like what was it that meant that those alternate options were not viable? Again, they will look at costs, but they're going to need very concrete evidence, and some costs will be okay. And when you're looking at costs, the other thing to remember is you have to offset any benefits that the employer might get from the accommodation, right? Was it deductible for income tax purposes? Were there government subsidies? Would it have been good for employee morale and therefore labor productivity to put in the accommodation? Makes it easier to recruit and retain employees, right? So there's also, in terms of costs, there's things that will offset the cost. And did the employer look into that? Did they consider it? Did they apply for these government subsidies? You're going to have to furnish evidence of all that before you can say, look, I can't accommodate. The other thing to look at, is it necessary to have all employees meet the single standard? Or could you do things on a more individual level? So could you do individual testing? So for example, there was a long line of cases about mandatory retirement at 60 for things like pilots, police officers, et cetera. And there was some idea with that, okay, well, they have to be fit. They have to be a certain, you want your pilots and police officers to have a certain level of fitness. Fine, but could you have individually tested them, right? Instead of just saying everybody at 60 is no longer able to do those things, could you test them?
What about a timeline? What if you have an employer that drags their feet up looking into the accommodation? Can you speak to that a little bit?
Sure. So so the question is about timeline. If an employer is really dragging their feet, that would go to whether or not they've actually fulfilled their duty to accommodate. So if they say, okay, well, we're going to look into other options, and they do nothing for a year, and no board or tribunal is going to find that reasonable. Like if they've done literally nothing, essentially what's going to be found is you didn't look into other options, therefore you did not meet your duty to accommodate, right? if they've done nothing for 4 days, well, then they're going to have a little more time. So again, that's going to be very fact specific, but absolutely dragging your feet, because what that is indicative of is that they're not actually trying to accommodate. They're just trying to make you go away. So I'm just looking. The other thing to examples of accommodation, so things that might work or have worked in the past, is ergonomic assessments, altering the workplaces ergonomically, having reduced hours, having reduced or different responsibilities, or changing what employees do what to meet accommodations. You can modify standards or targets. You can give people time off for appointments. You can give them different tools to do the work. You can make changes to the workplace or the facilities. And you can have more inclusive policies, procedures, systems, and activities, right? Again, change the time you're doing the meetings. So those are all examples of things that will be ordered as typed, or that will meet accommodation. What the question is, if you're a person requesting accommodation, what is it you have to do? So your obligation is to communicate the need that you need accommodated. So, hey, I'm facing this discrimination and I need it fixed. I have a medical illness, and so I can only work 4 hours a day. I need that accommodated. So you have to communicate the need. You have to communicate, this is what's happening, and this is what I need fixed or accommodated or whatever. You may be required to provide some information on that, right? So again, it might be medical information in the sense of, I can only lift 25 pounds, or I can only work 4 hours a day, or whatever it is, but you may need to provide some information so that the accommodation can be properly tailored. And you do have to work with the employer to arrive at an accommodation. You are not entitled to what they call a perfect accommodation. You are entitled to a proper accommodation, but let's say you need something accommodated and there are 5 ways to meet that, and all of them are good, and you prefer option 3, you're not entitled to demand option 3 as long as all 5 actually meet the requirements and are actually an accommodation. So you are entitled to accommodation, though not always your preferred accommodation. So that sort of gives you an idea, right? So I've talked about discrimination, how you prove it. You have an enumerated ground, you have an adverse impact, and the adverse impact is tied to the enumerated ground. And then once that happens, it flips over, and they're going to have to show that the policy or decision is rationally connected to what they're trying to do, that it was brought in an honest and good faith belief. Again, those are often easily proven. But the third part, and there was nothing they could do, there was no way they could accommodate you short of undue hardship in order for them to be able to justify the discriminatory treatment. Okay, so I'm going to turn it over to Raphaëlle now, and she'll talk about what happens.
I wonder if there's any questions, because I think I'm mindful of time, so I think maybe we'll jump to the presentation, and then if there's still time, then I'll do my section. Okay. Any questions on Alison's presentation?
Do you have presentation you can have?
I actually don't, but I could. I will try and put something together, and I'll send it to the Law Society.
Yeah, pull something together.
Yeah. Thanks. And we may also be able to get the slides for this. So. So Pauline, if you can hear me, the floor is yours.
Okay, can you hear me okay? The volume's okay there?
Yes, that's perfect.
Okay, perfect. Thank you so much. I would have loved to have been able to join you folks in person today, but I am very grateful to be joining you from the traditional territory of the Anishinaabe, now known as Huntsville, Ontario. So I'm quite far away from you folks today. It is a very rainy, blustery day, so I hope that you folks have a little better weather for your events today. My hope for today, I'm going to share an overview of some information from our programming that I hope will be helpful to you. Maybe it will be new learning. Maybe if you're very knowledgeable in this area already, that you are reminded of something that will be helpful to you. I've worked for the Mental Health Commission for almost 2 years. I've been a trainer in this program since 2015, but most of my career was as a paramedic. So I did that work for 26 years, and now I'm very grateful to be supporting folks from behind the scenes in mental wellness and education for our first responders and actually all Canadians. Our program's the Working Mind. So we have different iterations of this program. We have it for, we're developing one for high school age folks. We have one for post-secondary. We have for first responders. We actually have a legal adaptation as well now. But the program overview is pretty much the same in all of them. We want to talk about mental health. What is it? What is stigma? How do we talk about it? How do we talk about mental health in the workplace? What are stressors? What does that mean? What is resilience? Which really is coping mechanisms. And at the end of all of it, how do we make a difference? Not just for others, and how do we support our colleagues and our friends and our loved ones, but how can we support ourselves as well? Perhaps a little better than we have in the past. To get us on the same page, the World Health Organization defines mental health as a state of well-being in which every individual realizes their own potential and can cope with the normal stresses of life, can work productively and fruitfully, and are able to make contribution to their community. So it's not just, mental health is not a state of illness. Mental health is just like physical health. It exists on a continuum. Mental health and physical health are just health under that umbrella. So if I wanted to improve my physical health, I can choose to do that. I can walk more. I can make different choices in the foods that I choose. I can stretch more. If I want to improve my mental health, there are steps I can do as well. If I'm feeling overwhelmed, there are things I can do to help that feeling. If I have a lot of negativity and high stress in my life, I can edit some of the external negative things, like maybe the nightly news, or delete certain people from my social media feed, so I'm not experiencing as much negativity. When we think of that continuum, it exists on this spectrum, going from green, healthy, normal, usual functioning, whatever your normal is. Again, it's not related to measures between me and someone else. It's just what is normal for me. Yellow is our normal reaction to things. Car won't start, challenging conversation with somebody. We tend to go between green and yellow fairly regularly. Now, as noted at the beginning of the talk this morning, it's been a really challenging couple of years. You know, we're not all in the same boat, but we're certainly in the same storm. And I don't think it would be unlikely that many of us have been in the yellow more than we have in years past. But when we continue to move through that and to the injured stage, that's when you have more severe, persistent dysfunction. So you're not as joyful as you used to be. You're not doing the hobbies that you used to do. Noticing things are changing for you. And then in the red, you might meet the criteria for a diagnosable mental illness, but that's not necessarily that you would be diagnosed. And that can happen for lots of reasons. Maybe there's access issues, which is very common, or perhaps you don't know that there is a different way to be. So you exist in this way, and don't seek treatment and don't seek help. Years ago, when I first learned about this continuum, I was a paramedic, I was a manager at the time, and I discovered that I had been in the orange for probably a decade and didn't know it. So it's very common to not know where you actually are on this spectrum. Now, to think about a physical health example, to just hopefully tie these together for you, I have my friend here who I believe, I always say they are a robot dancer, and they have a very strong ankle. They can dance as much as they want to, and when they're in the green, they can do everything they want to. In the yellow, maybe that looks like a sprained ankle. Maybe they'll need some time off their ankle. Maybe they'll need a little bit of support. Maybe they'll need a tensor. But for sure, they can get back to the green. In the orange, that might look like a broken ankle. They're going to need more support. They might need crutches. They might need physiotherapy. But absolutely, they can get back to a healthier state and dance again. And then in the red, having a severely broken bone or bones might require surgery, for sure will require physiotherapy. But again, they can get back to a healthier state from this state. There's 5 categories that we look at when we're talking about moving across this continuum, and that's mood, thinking and attitude, behavior and performance, physical, so things like self-care, sleeping, exercise, eating. The rest are pretty self-explanatory. And then, of course, substance use and addictive behaviors. Now, when we talk about substance use and addictive behaviors, we're not just talking about alcohol or illegal drugs. We're also talking about prescription medications that might be used inappropriately or off-label, as they say, or other behaviors like gaming or gambling or shopping or even binge watching TV shows or series where it's taking you away from the things you want to do. And the decision really comes down to if there's three aspects that are being impacted by these behaviors, and we all do unhealthy coping from time to time. We absolutely all do. And that tends to be okay in the short term, but definitely in the long term, they have problems on their own. So if these behaviors and activities are impacting your finances, if it's impacting the relationships that you have with others, or if it's impacting your ability to work, then it's likely time to get some support. Now, we do believe that recovery is not only possible, that it should be expected. It is the foundation that regardless of diagnosis or situation, we can all move back towards the green or better health. And we want to make sure we are keeping this idea or this lens around recovery in hope, dignity, and inclusion. So being hopeful in a person's strengths and capabilities, even when there might be difficulties with mental health problems or illnesses. And then when we talk about dignity, of course, that's treating people with respect and supporting their journey of healing and growth. And then inclusion, absolutely, we don't want to be making decisions for people. We want to be making decisions with people about their care, their recovery, what's important to them. Now, there will always be barriers to care. I don't think, I wish we could get to a state where there wouldn't be, but sometimes there are just things that are insurmountable. And sometimes we can just choose maybe the smallest thing. What is one thing that will move us forward today? What is something I can do, whether it's reaching out to somebody or whether it's doing something for yourself. Sometimes it just is as simple as following your healthcare provider's program plan, or maybe it's just saying no to something. Because this is specific to workplaces, I think this is some interesting facts to share. That the average Canadian, of course, spends about 40 hours a week at work. Sometimes managers, I'm certain lawyers may be at the same point, will spend more than 40 hours a week. Why is that important? Well, only about a quarter of Canadians are comfortable talking about their psychological health at their workplace. And almost half of all disability claims are related to mental illnesses. So clearly there's a gap in support. Now, whether it's because the person doesn't feel safe at work disclosing that, whether they have some self-stigma around that, that's a little bit unknown, but there are definitely some gaps where people maybe could have been supported if they felt safe to do so. Now, employees who have more than one issue, mental and physical issue, stay off work the longest. That's no different than somebody who has multiple injuries or illnesses. It just takes longer to heal. I heard some great conversation around legal definition of discrimination. And when we think about stigma and how we look at that, stigma falls under the umbrella of prejudice and discrimination. It really ties those together and is the overarching term. Now, prejudice, that's our belief system. That's the thoughts and beliefs that we have from our families of origin, from our education, from our community. And it matters because if we have a negative thought about someone and we choose to act in a different way towards them, that could be considered discrimination. So if I don't trust somebody who has a mental illness, that's a thought, that's a negative prejudice that I have. But if I change the way I work with that person, if I don't invite them to certain things that I invite other colleagues to, that would be considered discrimination. So we want to be mindful of how we are thinking about these things. And when we break stigma down into these three categories, self, public, and structural, really self is our own negative beliefs. I'm not good enough, I'm not smart enough, I don't deserve. Public is, of course, what other people think of a category of issues or people. And discriminatory, like structural discrimination, those are the rules, policies, and laws. So if an organization, say, had a sick time policy that only granted sick time to people for physical illness and not psychological illness, that would be an example of structural stigma, which can trickle down to public stigma, that the group of employees believe that you can only take sick time if you're physically sick, not psychologically sick. Then that would be public stigma about that. And then you as the individual employee might think, well, I'm not allowed to take time off for psychological illness because only sick is validated, physical sickness. So you might start to believe that psychological issues are not part of health, which is completely not true. So all of those are interconnected and woven together. Now, having a psychologically healthy and safe workplace is one that we have to work at together. Just like physical health and safety issues, we have to work at that together. No employee or employer can do it on their own. It's something that is a shared responsibility. Now, we talk a little bit about stress when we talk about resilience and we talk about psychological health, and there are lots of internal and external stressors that we deal with. Now, we don't have a lot of control over those external stressors, but we do have a choice in how we respond to those things. We might have more control over our internal stressors, how we think, how we feel about things, how we frame things. And we talk about that in our programming. We use the big 4 strategies. Now, some of you have probably heard of these: deep breathing, mental rehearsal, positive self-talk, and goal setting. And we use these strategies in order to support ourselves. These are evidence-based techniques that have been proven to clinically reduce the stress response when we experience stress in our lives. There are lots of tools and resources online that can help with all of these things. Just deep breathing alone will move us from that overwhelmed state, that fight, flight, or freeze state, into the place in our brains where we can make creative decisions or come up with ideas about things. Because when we're in this stressful, overwhelmed reaction phase, we're not in that part of our brain that monitors our higher critical thinking. So just the deep breathing one alone is enough to help reduce stress and anxiety to get you to a place where you can make more sound decisions. So we don't have time to go through all of these today, but I just wanted to give you a little bit of an overview of them. And just remember that I think that one of the things that we certainly need more of in every aspect of our lives is empathy. And that's defined as a person's ability to share emotions of another person. So when somebody tells you a story or shares their story with you, I always honor that story and try to find that feeling or emotion to connect with their story and recognize, that might be very difficult for them. And we don't always have to know what to say when somebody shares something with us. It's enough to say, I don't know what to say right now. I'm just really glad you told me, so you can figure it out together. So we want to be mindful, we want to be respectful when we're dealing with folks, and be empathetic towards ourselves, right? Because self-care is very important. You can't pour from an empty cup. We want to be taking care of ourselves so that we can take care of others. And I'm just going to briefly show you these couple of slides. There are lots of things to do in the different colors of the continuum, how we can support others. Even in the green, there's work to do. How do we stay in the green? How do we have a healthy work environment? In the yellow, how do we make sure people know the resources that they can access? In the orange, supporting folks, making sure that maybe you're helping them with the paperwork that they need to help. Minimize rumors and gossip. We still have to manage unacceptable behaviors. And certainly in the red, make sure that people have the support they need. And I like to always share that we want to stay connected to folks who are not in the workplace. Once somebody leaves the workplace for a medical leave, whether it's because of physical illness, injury, operations, or psychological issues, they've lost an entire support network. So it's okay to reach out and check in on them. It's, maybe if you have a relationship with them where it's okay to text them, you could text them and say, hey, I was thinking about you today. Or, so-and-so had their baby. Or we're having a get together because Joe is retiring next week. We'd love for you to come if you could. So it's still okay to connect with people who are not in the workplace. Just a moment on support and resources. Think outside the box sometimes. We have lots of resources that are online now. Not everyone has equal access to that, but there are always somebody that you can connect to, whether it's a colleague, whether it's a work buddy, whether it's an elder, spiritual leader, healthcare provider. There is help out there if we reach out. If you have any questions or comments, I'd love for you to email me or send it through these folks who are giving this presentation today. And I hope that you have time to go through the rest of your presentation. And I'm happy to stay on and take any questions that come up.
Thank you so much, Pauline. Do you have any questions for Pauline? Do you have to, so we have around 50 minutes. So maybe I can cut it to 5. I can progress through it. Okay, super. Thank you so much, Pauline. If there's no questions for Pauline. Pauline, I guess you can stay, or you can, or we can say goodbye.
I'll just mute myself and hang out in case something bubbles up, but I'm certainly not offended if there are no questions.
Thanks, Pauline. So I am mindful of time, so I'll do this very quickly, but I just think it gives a few ideas if, as an employee, sort of what our options are if things aren't going well, and we're realizing that maybe we shouldn't be in the workplace any longer, maybe we need a bit of a break, or if you're more of a manager and employer, maybe options to sort of guide your employees. So, taking on from what Alison was talking about in terms of accommodation. So let's say as an employee, you've asked for accommodations, things have been put in place, but it's still not working out great. You're still either physically ill and your physical symptoms or limitations are impacting your ability to work, or if it's from a mental health perspective, it's just not going well. So you've tried the accommodation, that doesn't work, or accommodation isn't even an option given your limitations and restrictions. What can you do? So one option is if it's caused by a workplace injury, and it happened at work and it's because of something that did happen at work or occurred at work, then you do have the option of filing a Workers' Safety and Compensation Commission claim. With respect to the mental health aspect, one of the things that's important is it can't just be related to sort of normal workplace stress or conflict between colleagues. It has to be either one sort of very traumatic incident or accumulation of sort of micro traumatizing events, so like continuing a harassing behavior, to be able to make a claim for workplace injury, and it has to have happened at work. So that's one option. In terms of short-term options too, sick leave, using up your sick leave credits, and taking those. And what I also always recommend is if you have short-term disability or long-term disability through your employment or purchased privately, you want to start thinking about it at that point, because it does take a lot of time and there's usually a waiting period to get onto disability benefits. But it is a long process. So you want to almost start thinking about it earlier on before you get to the deadline when you need to be applying. So that should be on an employee or an employer's radar in terms of advice to an employee. And then the other option is EI sickness benefits. So if you've been paying into EI, you are entitled to 15 weeks of benefit leave. It's not your full salary, so it's 55% up to 638 a week right now. And you need to just show a medical document demonstrating that you can't work because of a medical condition. And that medical condition can be both physical or psychological, cognitive, or as we describe them, sort of invisible illnesses. And the one that comes to mind the most is sort of fibromyalgia. So no one really knows, like, is it physical? Is it psychological? Those ones tend to be a bit harder to accept from the insurance companies or from the ones paying, just because I think people still have a very misunderstanding of these conditions because there's no sort of like physical outside demonstration of what these look like. But I think we have come a long way in the last few years, thankfully. So like I said, you use up your sick credit, you start thinking about long-term disability benefits or short-term disability benefits if you have that, and then EI sickness benefits. So that's more on the short term. If you start seeing that this is going to go on for some time, then long-term disability benefits or even CPP, so Canada Pension Plan Disability, are sort of the longer term options. And those are just the way that the definitions, to be able to demonstrate that you meet the definition, you have to be able to show that it's from and I'll take long-term disability benefits. So you have to show that for the first 2 years, because of your medical condition, you can't do your own job. Okay, so the threshold is not very high, right? You have to show that here are my general duties, here are my limitations and restrictions, and those two are just not compatible. And that, depending on your policy, either that's the definition for short-term disability or for the first 2 years of long-term disability. After those 2 years, you fall into the any occupation disability benefit definition. And that's having to demonstrate that because of your medical condition, you can't do any job that you would be trained for, and that, that would meet a certain salary level. Again, all the policies are kind of different, but that's generally what we see. So that threshold is much higher, right? You need to be able to say, I can't work in any capacity. And so that takes very strong medical information, usually from specialists. Those are always more accepted and more valued in a way. Unfortunately, I think just because access to specialists is much harder, but to demonstrate that you meet that definition. And then people can continue on for long-term disability benefits until the age of 65. And then the last sort of resort would be Canada Pension Plan disability benefits. And that's the much higher threshold. And that's demonstrating that your disability is severe and prolonged. So chances are you will never fully recover, that it is either terminal or that there is no chances of getting better, and that you can't do anything. So that's literally, I mean, it's looking at it in a real world situation. So if you can say, I can do something, but I can only do it 1 hour a day. Well, the reality is no one's gonna hire you for that. So, I mean, it is in the context of a real world, but you have to show that you can't do anything. So that becomes much harder to prove. And so we tend to see in our practice, for LTD, for long-term disability benefits, and CPPD, there's like two, there's either denial from the beginning, and then you have to go through the steps of appealing or litigating for long-term disability benefits, or appealing and reconsidering for Service Canada. But with long-term disability benefits, we also see a very, the moment where that disability definition changes. So where you go from having to demonstrate that you can't do your own job to demonstrating you can't do anything, we sort of see that is a time where insurance companies sort of jump on that occasion to deny benefits or to cut benefits. I think it's like an easy sort of out for insurance companies, and having worked with them for a number of years now, they will try as much as possible to sort of get out of paying claims, unfortunately. So just to keep that in mind. So I think I did that in 5 minutes. I think that is, I don't know if there's any questions on that. Yes.
You can
Repeat.
share the question again.
Okay.
So it's not easy to kind of bring it up to your employer sometimes when yourself you're not feeling well, but based on your practice, like how important is that to take that courageous step, and what can you share to encourage employees to make that step? Because it's about your well-being.
Yeah.
It's not easy, right?
So the question is sort of, what is the advice that I would give to employees, because it is so hard to sort of come forward with these requests or these issues. And I think my answer is both from a professional, but also just from a personal level. All we do is represent employees. So we understand that there is a huge sort of in power imbalance between employees and employers, and it can be very difficult. But I think that the reality is that because we spend so much time at work, it affects us in every way. So when things aren't going well at work, usually your personal relationships aren't going well. If you have kids, you're losing it on your kids. Like, it's just nothing else goes well. So I think at one point we just have to take the courage and deal with it, or else our lives will just suffer from it. But I also think that the other problem is, if we're not doing well, then it affects our job. And then that leads to other issues, right? Then maybe you're getting terminated because you're not performing well. Then that's another stress that you're going to have trouble dealing with. And from a medical point of view, at one point, if you don't address it, it just gets worse. And then to recover from that becomes much harder. And even the statistics show that if you go on leave, basically after 2 years, if you're on leave for 2 years, your chances of ever going back to work are hugely diminished. So there is a 2-year mark. So, if you're still at work and you're not doing well, and you're pushing that and not addressing it, at one point, your capacity to deal is going to be so limited that I think you go on leave, and then your chances of coming back are so reduced. So, and that's not to say, I think there is a real, I think we're getting better. I think in our profession as lawyers, we need to make an effort to talk about this. I think we were trained in law school. I think the message around what lawyers should be, how we should act, You know, for the longest time, we were told like sort of mental health doesn't work in our profession, right? Because there's this myth that mental health is a weakness and that as lawyers, we cannot be weak and we must be strong, and sort of this like idea as gladiators. But I think that we as a profession, not only because our numbers of mental health are so high in our profession across the country, addiction and substance use in our profession is extremely high. We owe it to ourselves to talk about it. And I think that that will trickle down into other professions as well. If they see lawyers talking about this and being open about mental health issues and struggles in our workplaces, that hopefully that will have an impact on other professions. Yes. Yeah.
Would you have the resources for public service healthcare? Like, do you review cases with lawyers getting support?
Yeah. So we, and I probably, so the question is, could we help sort of review claims for these benefits? And I probably should have started with that, but Alison and I, so our firm is, all we do is represent employees, or unions will hire us to represent their members on anything related to workplace issues. So literally under the umbrella of like work and work-related issues, we do all of that. And so a big part of my practice is actually advising people on disability benefits and what's available. And if they get denied, what can we do? Sort of, you know, is it an appeal or do we have to litigate, unfortunately? And luckily, most of the time, you know, we don't have to litigate. There's ways around it. But yeah, that's definitely something we can help with. Yeah.
And I can just jump in. If you would be interested in making an appointment, I'm talking to you, but I'm talking to anyone. If you are interested in making an appointment with a lawyer, Raphaëlle, or maybe someone else, I'll give you my card. You can email me that we can schedule something. It's 100% free, 100% confidential for an hour and a half meeting with a lawyer.
Would you have a follow-up question?
I lost the train of thought.
Oh, okay, if it comes back to you, let me know. Okay. Any other questions?
So I just wanted to thank everyone for joining us. And Pauline, this was really, we saw you at the Community Food Center as well yesterday, and your colleague Sabrina did the Francophone session last evening. So it's a general overview, but we're hoping that getting the word out on these topics, and it's not easy to take those courageous steps, will encourage you, colleagues, to take that step. And as Romy mentioned, there's opportunity to meet with lawyers who are members of the Nunavut Bar, to have a 1 hour, 1.5 hour free session on some of these topics. If you're going through something at work, or you just want to get information before something gets really difficult, then you can reach out to Romy and take advantage of that free hour, an hour and a half about. And for our Nunavut Bar members, not Pauline, we won't ask Pauline to do the survey, but Romy will follow up with the survey.
Yes.
And hopefully Pauline will be able to welcome you another time. This was really wonderful, but to kind of dive into a little bit more some of your topics, which was great.
Yeah, so for the members online, so you will receive an email from me with a PDF, fillable PDF with a survey. You don't have to complete it, but it's always nice to have your feedback. And for the people here, I will give you a survey. Once again, you don't have to complete it. And we have gift cards to draw as well.
Yes.
And I will give you my card.
So thank you again to Alison and Raphaëlle. They've done a couple of sessions during their trip. It was a short trip, but quite busy. And I'm thankful for that, for sharing your knowledge and information. Thank you, everyone. Have a nice day. Have a nice week. Enjoy the nice weather too. Bye, everyone.
Bye, Pauline. Thank you.
Members of the public, lawyers are members of the public.